All right. Any other agreed matters? All right.
Your Honor, number 1 on the docket.
I'm getting to it, Ms. Holder. I saw it. And folks, you need to understand, I do not check chat. I know in Clark County, they have someone who checks what goes on in chat. I do not. I cannot do that and admit people. So with that, on number 1 and number 2, the Randall matter, that matter was on last week and addressed. So there's, it was set over to March 26th. So there's nothing today. Okay.
Thank you, Your Honor.
Your Honor, I was wondering if we could set over a matter.
Hold on just a second. Okay. Which matter, Mr. Anagnostou?
Number 11 on the docket, Edmondson and Edmondson.
You must be looking at the old.
Maybe it's
that was already removed
Okay.
and dealt with.
Okay. Thank you, Your Honor.
Okay.
And Miss Talishog is here. I don't go by early wine.
All right. According to the record, we have to at least call the name early wine because that's still the record of what it is. So we have, so at this point, I do not have any responsive pleadings. So I need to know what Ms. Bliss.
And Your Honor, I have not received anything from Ms. Talishog either. I did receive the sheriff's proof of service from the most recent extended restraining order, and Ms. Talishog was personally served on the 4th of February. So at this point, I'm asking the court to adopt my requests as they've been presented.
Is it Talishog? Is that
Talishog.
okay?
Actually, I wasn't personally served on the 4th. I was served just not too long ago by a sheriff at my work, but not the 4th. The first time around, somebody trespassed actually on my property. We have a gate and even signs that say no trespassing, and I have videos as well. But yeah, somebody attempted to first serve me prior to the first court, wasn't able to make it due to work, and then again, served at work. I don't feel a need to respond. A lot of this is lies. I told my daughter once her father was stable and able to take care of him. I'll just say it short then. I don't want custody.
Stop.
I don't want anything.
I'll just mute you if you don't stop when I ask you to stop.
Excuse me, I've already stopped.
You do it again, I'll just mute you. So the problem is that at this level of court 1, I believe that Ms. Bliss, I saw a service on February 15.
Yep, that's when I got served. Let's make this simple. I don't want custody. So whatever needs to be done, I'm not going to subject myself nor my other child I have here to my daughter's behaviors, her physical behaviors to my son, and
I asked to talk to Ms. Bliss, not you at the moment. Ms. Bliss.
Thank you, Your Honor. And the February 15th was the service of the order extending the immediate restraining order. Ms. Talishog was personally served by drop service on February 4. There was an affidavit from Mr. Gilman indicating he attempted service, went to the home, dropped the documents, and then was later shot at by Ms. Talishog and or her husband. So at that point, he was no longer willing to continue attempting to serve her. So we were forced to utilize the sheriff for the order extending the immediate restraining order. However, she was served with the initial documentation on the 4th.
So Ms. Talishog, and I apologize if I'm saying that incorrectly, based on the fact that I see that there was proper service, that it's been at least 11 days since the second service, that I will be signing off on these documents. I did review the files and record. Based on the files and record, the court does find adequate cause. Further, the court does believe it is appropriate to keep the restraining order in place. The proposed parenting plan is approved. The father shall enroll the child in school within 72 hours of entry of the order. And then, Ms. Bliss, are you still requesting a guardian ad litem?
At this point, given the fact that she's not contesting, I don't think one's necessary at this time.
Okay.
No, I'm not contesting anything. Like I said, I'm not going to have her in my home with behavior she has, not only to me, but to my other child in this home.
I've heard it. I've ruled
and sexual.
Enough. what I need to
behavior,
know
too.
at this point, Ms. Tolshog,
Talashog.
I'm sorry. I don't mean to keep misstating it. So I need to know if you approve via Zoom on the orders.
I don't approve any of these orders. I don't agree with what's being said in there. The only thing I agree with is that he can have her. I want nothing to do with her. I wish her the best life over there. They
Okay.
can deal with all the chaos.
All right, I will be signing off on the orders.
Thank you, Judge.
That concludes this matter. And Fragel?
That matters, Your Honor. Making Gilmore on behalf of petitioner, namely Tim Fragel.
Marcella Renee Fragel, currently present.
Thank you. All right. So I have a motion for order for leaving respondent's property alone. I have read through everything, and for some reason I am missing. I'm going to be right back. For some reason the notes are missing out of my file, but so I will be right back. Okay, so I apologize for the delay, but with that, Ms. Fragel,
Yes,
you there? Okay,
yes, I am.
all right. And Ms. Gilmore?
Yes, I'm still present. Thank you.
Okay. All right. With that, in regard to the motion, I've read everything from you, Ms. Fragel. I don't need to go through everything that you wrote. Is there anything that you wanted to add?
No, Your Honor.
Okay. Ms. Gilmore, I've again read what the response is. Anything you wanted to add?
No, really just in summary, my client agrees to the standard prohibitions on property, moving, selling, hiding. We mainly are just looking for a remedy here so that we're not before the court again in another issue. I think that the remedy would be moving the property out into a storage unit. She then accesses the storage unit or keeps the storage unit. Alternatively, we set another civil standby so she can access the property. My client just can't continue to live under the current conditions that she was living in the house. And we are just trying to remedy this issue so we don't have to seek any more court intervention.
So,
Your
Ms.
Honor, I object to that.
Okay, so Ms. Fragel, what about a standby of going in and getting your things?
I am not restrained from the home, Your Honor. I don't need a standby. I just need to be able to get into the home.
Ms.
She's
Gilmore?
restrained. Sorry, Your Honor. It's my understanding she is restrained from having any access to my client's residence, his location, etc. My client has previously agreed to an exchange of property through my client's brother, which he'd be willing to do so. Again, I guess we just need a clear understanding of the property she wanted to access. So that's not a problem for my client. We are willing to facilitate that.
So if there's a restraining order in place, Ms. Fragel, it would require a standby for you to go to the house.
But I am not restrained from the home. I'm only restrained from Mr. Fragel.
Okay. Without seeing the order, I can't tell you. So bottom line is, I want it understood, I'm not here today to decide which person gets what. This is a request for temporary orders. And so with that, I'm not going to get into the whole, this person gets this. I understand, Ms. Gilmore, what you're talking about, but I think you're going to have to bring your motion and show the stand or restraining order because I don't see it.
Okay, if you would like me to do that, it's just a little difficult because the property's throughout the house, but maybe we can coordinate amongst ourselves. I mean, like I said, I understand the normal prohibitions on property. I'm not going to advise my client, obviously, to move, hide, sell, damage. He denies doing so. So I guess we'll just have to deal with it moving forward as we progress the case. We do have a settlement conference set up for, I believe, April. So hopefully we can get this resolved.
Okay. So at this point, neither party is to move, take, hide, damage, borrow against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic necessities. Both spouses or domestic partners must notify each other about any expenses that are out of the ordinary. Also, neither party is to open, dispose of, delete any mail, be it email or regular mail. Okay, so that's what I'll order. Ms. Fragel, it will be up to you to get an order, or Ms. Gilmore, can you prepare a standard order and get it to Ms. Fragel?
Yes, I can do so.
Okay, so Ms. Fragel, Ms. Gilmore will get you a standard order, that's standard language in a lot of temporary orders. And that way we can get that into place, okay?
Thank you.
All right, so I'll go ahead and set this on for a presentation. Let's see, we're on, Ms. Gilmore can get an order prepared, okay?
And what is the presentation on March 12th?
It's just to get an order to put this, what I just ordered, into place. It needs to be reduced to writing. And
Okay,
Ms. Gilmore is going to go ahead and do that.
thank you.
All right. All right, that takes care of the matter for today. Garcia
Thank you.
v. Ojeda.
Good morning, Your Honor.
Good morning. Morning, it'll be just a second here.
And then I did request an interpreter to attend this hearing. Should be-
At your service, ma'am.
Okay, perfect, thank you.
Okay, if the interpreter would identify himself in the language he's interpreting.
Good morning, Your Honor. This is your interpreter for the Spanish language, Raúl Aguirre, permanently sworn through the AOC, Your Honor, and also certified through the DOJ as well. Muy buenos días. Un servidor de habla hispana de Juárez, Chihuahua, Raúl Aguirre, a la orden, facultado para todas estas interpretaciones conforme a las normas estatales.
All right, so counsel, I did review the files and record and what was submitted. So with that, anything you wanted to add or state?
Yes, so it does seem that Mr. Zandy and I have been able to come to an agreed child support order. We can get that to you ex parte later in the week.
Judge, to clarify that parties have agreed to a monthly transfer payment of $612.
Counsel, your voice is coming in a little bit soft also as well, with all due respect, of course.
Is that better?
Oh, glory be. Yes, sir.
Yeah.
I can talk loud. I'll try to keep it within range. Parties have agreed to the $612 per month. Also agreed that my client claimed the child on the 2023 tax exemption. Parties will split equally the costs of work-related daycare as well as uninsured medical expenses and remaining tax issues pertaining to the past arrearages that might be in effect are essentially reserved, including the credit for the $2,000 that was paid by Mr. Garcia. My understanding is that leaves parenting plan and visitation issues along with attorney's fees and costs. With that, I'll turn it over to counsel.
Y con ello, me remito a la palabra de la abogado.
All right, I will keep this brief since Your Honor has reviewed the pleadings. Mainly, we're just trying to establish a consistent parenting time schedule so that father can have more time with the child. And then the only thing I'd like to note that has slightly changed in the proposed parenting plan that we submitted is because father has had a new job, so he has different days off now. So in the proposed parenting plan, it would just have to change to Sundays to Monday instead of Monday to Tuesday, same exact time though. And then Fridays, 11 a.m. or 8 a.m. to 11 a.m. instead of 9 to 1. And then just one other additional fact that has come up is father has voluntarily undergone a hair follicle test for alcohol, and that has come back negative. I've sent that over to Mr. Zandy's office last week. So again, I know mother had concerns about father's drinking. Father would just like to reassure that he has stopped drinking.
Let's let the interpreter interpret.
But otherwise, mother has not listed any 191 factors in her parenting plan. Father has shown commitment to establishing a bond with the child. So we are just asking for the proposed parenting plan that we submitted to be approved by the court.
I appreciate counsel standing, but I think it's more important to just sit and be right in front of that mic. Mr. Zandy.
Señor Sandy.
And thank you, Your Honor. I do represent the non-moving party, the original respondent, Justine Ojeda, by noting that this is a very young child, 6 months old, Gianna. That was the product of a very brief relationship between these parties that was essentially only several months in duration. Parties moved fast when they were dating and discussed and contemplated marriage, only for that to tail off when my client found out. And they essentially broke up when my client found out that she was pregnant. Leaves my client in a very difficult position of trying to foster a relationship between Mr. Garcia and the child when she really doesn't know him very well. Parties need to develop trust with one another, but we also need to maintain the safety of a young 6-month-old baby who essentially cannot care for herself. My client is still breastfeeding and works approximately 28 to 30 hours per week, which also creates complicating factors. She's tried her best to foster the relationship, and I think that's evidence in the pleadings by having Mr. Garcia present at least once a week at a local coffee shop. There's an air of mistrust due to some of the observations my client has had of Mr. Garcia, including alcohol consumption and his care of the baby when she is present. We've detailed many of those experience and observations to you in my client's declaration, and it's many of the fundamentals of child rearing, including bottles and holding the child's head, changing diapers, and those sort of things. Reality is it takes time to grow accustomed to care for a child, especially a young child. What we're suggesting moving forward is a visitation on a phase-in scale, which makes sense and is certainly in the best interest of this child. My client's family, her mother and father, have extended a welcome invitation for Mr. Garcia to have visitations with them for a period of time, hoping to ease some of the comfort with the child. We have the benefit that they have somewhat flexible schedules, and unlike some cases that we routinely see in this court, there's absolutely no ill will between my client's parents and Mr. Garcia. Once or twice a week, again, as arranged by the, I don't even want to say supervisors, but the parents, I think, is certainly appropriate as the child is comfortable there and they have a lot of experience with children. In the meantime, we get a GAL on board who can look into some of the issues my client has expressed concern about and ensure that the visits are going well, and we can come back in a period of 2 or 3 months and address additional time. In the meantime, the suggestion or the request of Mr. Garcia for overnight visitation seems somewhat premature, because again, there are far more questions than there are answers at this point. And one complicating factor, my client's mother has some medical issues that may require treatment. If she's unavailable or the parties can't agree to an alternative third party, reconnecting families is always suitable in Longview. Lastly, we are asking for a contribution in fees and costs in the amount of $2,500. I think that's warranted based on the comments raised and concerns raised in my client's declaration. We would ask that any fees be paid within 60 days of entry of the order. And my client did want me to make sure the court was aware she is present. She is on the Zoom hearing. She had to work today.
May I reply, Your Honor?
Yes.
¿Me permite contestar? Sí.
So Mr. Zandy stated that mother has given father parenting time at least once a week. That is not correct. Father has seen the child around 11 times within the past 6 months, and about half of those times, mother has either rescheduled or canceled these meetings. And these rescheduled parenting times are normally told to him on the day of the meeting or the day before. Our parenting time is in stages. There is no overnight parenting time until I believe stage 3. And mother's proposed parenting time schedule is really not stages. It's just to keep things the way they are without any offerings of a different stage 2 besides getting a GAL to make a recommendation. And then as for attorney fees, we do not agree to that. Because no parenting time schedule was established between the parties themselves, father had to file to get this parenting time. Also, father has taken out loans from family members and his roommates in order to pay his attorney fees. So father is not able to afford to pay Ms. Ojeda's attorney fees as well. That's it.
Es todo.
So I have reviewed the files and record. And based on those files and record, I will rule as follows. In regard to the request for a guardian ad litem, I am going to appoint Jennifer Schaefer. What I want Ms. Schaefer to do is more of a quick turnaround to give a recommendation to the court in regard to time of the father with the child. This is a very young child and one that is breastfeeding at this time, recognizing there are things that can accommodate that. As well, the father is in the Vancouver area. The court does have concerns with someone that had a DUI and is known to consume alcohol. As to smoking, a young child can especially be irritated with the smell. So with that, I am essentially adopting the mother's parenting plan for now.
Así es que por esas mismas razones, yo fundamentalmente, yo opto por lo que es el plan de crianza, la propuesta de la señora madre por ahora.
But with some changes. First, we will have a review with input from the guardian ad litem. That will be on April 16. Until then, the father shall have time with the child 2 times per week. That will be for 3 hours at a time. The visitation shall occur at the parents of the mother in Cowlitz County. If the parents cannot accommodate that, then it will be through reconnecting families. That will be at the cost of the father. The father is not to consume any alcohol 8 hours prior to and during the time with the child. As to smoking, the father is not to smoke around the child, and is to wear cleanly washed clothing to avoid having the young child breathing in smoke. The father shall complete the classes he has started. The father shall also obtain a current substance abuse evaluation with input from the mother and the guardian ad litem. And that is once the guardian ad litem has an opportunity to investigate issues. So it is understood. I believe both parents are important in the life of the child. As indicated, there are some factors that are concerning, especially with such a young child. There will be further consideration of additional time once the guardian ad litem can provide meaningful input. In regard to attorney's fees, the court does see some difference in the incomes of the parties and will order attorney's fees of $1,000 paid within 90 days of today's date.
Very well. Thank you, Judge.
Gracias, señoría. Gracias.
I'm not ready, Your Honor.
All right. So I'm looking at the revised amended objection to petitioner's proposed order. That's what I'm going to rely on. So going to the temporary family law order. We'll come back to the section 5 part. Section 10. Please add make best effort to pay debts as follows. Your
Honor, would you like my comments?
Yeah, I know what you're probably know what you're talking about because I set a priority here. But go ahead.
Yes, Your Honor, that's exactly it. The court equalized the parties' incomes for the purposes of family support and my client's order to pay both land mortgages, as well as obviously family support, the auto loans, auto insurance. So at some point we need to prioritize what is going to be paid in the event that my client simply just can't make all ends meet. So we are asking that the court indicate within section 10, rather than say pay debts as follows, make best efforts to pay debts as follows. I also don't believe the court made any ruling regarding jointly held credit cards. Again, I think there was some discussion that all credit cards were in my client's name. However, if there is another credit card that we're not aware of, that wasn't addressed. So I do ask the court also strike that under debt 1, credit cards to husband, and strike or held jointly in both spouses' names.
Counsel?
Yeah, this is the case, if you recall, where my client indicated that she had no idea what had been done. This was the case where Mr. was going out and financing real estate. Well, we had a card that she didn't know anything about. She detailed for you. She never had access to any cards. So basically that language included kind of on that overriding theme of things. And until we exchange discovery, we just don't know what's there. Ideally, we would not like to ruin these people's credit because they're both going to need that moving forward. And again, he's been the only one to use the credit cards. So I included it as such into paragraph 10.
All right, so I'm just going to go through these. So section 10, in regard to the make best effort to pay debts as follows. I'm not going to add the language. I understand where it's coming from, where it's originating, but at the same time, I'm afraid if that language is in there, it's just going to be an open door to potentially not pay debts. I think they just need to look out for what they need to do and take care of things. So in regard to or held jointly in both spouses' name, I'm going to just include that because I do recall there were issues. If there's something that comes out in discovery that you need to bring it back. But for now, it's going to remain as currently put. In regard to temporary parenting plan, Reserving on the 191 factors, I'm not going to. I specifically made that finding and as a basis for restrict or limitations. And so that will stand. Number 5B.
Disregard then based on that ruling.
Yeah, so that'll it'll remain as currently stated. For section 9, I again intentionally have summer as the same. I was very specific in what was ordered as far as visitation time, and based on the allegations and what's there. And so at this time, it will remain as currently stated. All right, section 10. In regard to spring break, as far as it going from the day and time for the week, I'm not going to do that. But what I will do is split for now. So the spring break can be split.
Exchange on Wednesday at 5 o'clock.
Wednesday, 5 o'clock. The request for Mother's Day and Father's Day and all 3-day weekends, that's all acceptable to make those changes.
We didn't address transportation location. And it gets a little complicated because the kids have been riding the bus and my client lives in Toutle and the kids go to school in Toutle. So my client just wants to avoid the kids going all the way back to Longview and then being transported back to Toutle. So the difference between is either riding the bus or the parties meeting at a central location. My client believes the central location is the Castle Rock Shell Station.
Any concerns with that?
Well, and she lives in Longview, he lives in Silver Lake, so it's not near half. These parties have been going and getting her kind of the complaints of my client and some of the actions of dad at the Lexington Chevron, which again is approximately halfway. That's where they've been. It's well lit, it's well traveled. There is cameras there. We would ideally like to keep it there. Again, that's just consistently what they've done. I don't disagree with counsel on the school issue necessarily, but understand the argument, but again, I think it's a moot point if you look at the fact that they're exchanging these kids. From what I recall, Fridays at 5 to Sundays at 5, Wednesdays at 5 to Thursday morning, or 5 p.m. if no school. So I think the majority of the exchanges are going to occur at whatever location you set, but we just assume keep it where it is, which is that Lexington Chevron, which is approximately halfway.
Well, and Your Honor, I don't necessarily agree with that. I don't believe that was contained in any declarations. I would need to confirm with my client, but I don't think the Lexington has been happening. I believe the parties have been exchanging and having a lot of these alleged disputes at the school in Toutle.
So what I would suggest, what I would like is consistency, and that's where it becomes problematic. The less time that these parties can so they don't have to have contact, the better. So if it's something where I said 5 just because that's a standard time, and that's what it would be. But if they can just simply ride the bus to dad's place for, say, their Wednesday time, that's fine. If they can do it on Friday, just go home to dad's place on Friday on the bus, that's fine.
Just make it Friday after school and Wednesday after school.
Right.
Yeah.
All right. Section 14 additions, they all made sense to add.
And I do believe Mr. Zandy did add the telephone access and access to records. He did not add the address phone numbers on the top, so that just needs to be added.
Okay. All right, so the temporary child support order, let's go to that now. Is this something I was trying to recall from before? I guess I don't recall paying attention. I would think that the separate order would still have to be put in.
Typically, sorry.
Well, that's right. I usually include both in the child support order. They can do that, and it's a collection and enforcement issue. They can track those payments. We're gonna have better luck with him actually paying it. That's why I include and specify, like I did, the maintenance and quote unquote family support, which is the combination. I broke that down for DCS. I don't think they're gonna have an issue in interpreting that order. I think it's pretty clear. And they will do that if they'll collect any support provided it's in the order. and directed at them as such. So that's why that's included in there. I think it's appropriate. I think that's our best shot to get that money collected from DCS and enforced pursuant to the order.
Ms. Gilmore?
And Your Honor, I think in all of my family support cases, we've included in the temporary family law order and have not included a child support order. It's not appropriate to, or it's my position, it's not appropriate to enter it into a child support order because it indicates for the court moving forward that this is child support and fails to acknowledge that this is both spouse support and child support. So I believe it's appropriate to only include it in a temporary family law order, not include a child support order. There is a section under the temporary family law order that allows for DCS to collect within those forms alone. You don't need a child support order. Moreover, there's been no evidence that my client is refusing to pay. I can update the court that he has in fact paid directly to the other sides. My client would prefer to pay directly rather than involve DCS because it just simply causes back support issues for a delay of entry of order, etc. But I would ask that the court exclude the child support order, only include the language in the temporary family law order. I do think that it reads that he owes $4,600, which is not the court's ruling. It looks like he owes family support in the temporary family law order and child support in the child support order. If the court is inclined to enter a child support order, I have set forth in my objections. The court did not order any extracurricular activities. My client simply extremely overextended at this point. So there's just simply not enough money to go around with the current order, and I don't believe additional expenses are appropriate.
Well, and I don't know that you looked at the revised order, Ms. Gilmore, paragraph 10. It states support for both, support for court order, alimony support. We broke down those amounts, and then I put an asterisk in there that states child support plus alimony spousal support, total monthly family support amount $2,300, start date of 2/1/24, and 2 equal payments. And the problem when you get away from child support orders is there's tax issues, there's uninsured medical expenses, there's health insurance, there's other things that need to be included that are omitted from the temporary order. The suggestion is to strike what's in the temporary order. I would be fine with that. 6 of one, half a dozen of the other. But again, the beauty of containing this in one child support order is the collection and enforcement agency can do that without having to come back and waste everybody's time and money on contempt if in fact nothing's happening. My client needs that money. This is the surest way to get that done.
So what about the extracurricular?
I'll leave that up to your honor. And
Okay.
I agree with Ms. Gilmore. I don't think that was specifically addressed in the order. I think it was discussed about the kids as extracurriculars. I don't disagree that was not a specific finding of the court. I think it was included in prior order going back and forth.
So I am going to go ahead and have the child support order as proposed by Mr. Sandy, but not the extracurricular and those other items because one, I didn't rule on it. And two, I think with the amount and the intent was to take care of things for the family support.
But keep the uninsured medical, I'm assuming.
Right.
Yeah. Okay. Very well. Thank you.
I don't believe we'll need to set another hearing. I understand the court's intention, so we can circulate orders and I'll get signature out.
All right.
Thank you.
Thank you.
Your Honor, I filed a proposed order regarding a continuance. Earlier in the last week, we filed a notice of continuing the trial date. That wasn't sufficient, and so I just filed an agreed order of continuance, which I served on counsel. I don't agree with his form of the order because it's redundant, but it does not, it really doesn't matter, but my form of the order just makes more sense.
So Your Honor, with regards to that, I was unaware that the agreement between counsel had been filed with the court when she sent me an email telling me that the clerk said that was inappropriate form. I redid the form and so I was unaware that was filed. So when counsel indicated that this is redundant, I didn't know what she was talking about. So I thought this was the one and only order. So it's still the clerks require an order, Your Honor. So I've presented an order to you for today, and then I got another scathing email from counsel saying that she wasn't going to sign off on that, and here we are. I mean, we can't agree to anything.
So let me just, Ms. Cotto, I don't find your order.
I sent over a proposed order that I filed with the court along with a bench copy, which we dropped off with the the receptionist, and I served a copy on council, so I don't know why he's so surprised. They were all done. It was done, the 23rd, which was Friday.
No, no,
And
I just want to clarify.
if I could
Hold on,
finish.
one at a time.
And I also put on the bench copy the date and time of the hearing.
Let me go see if it's in back, because I'm not finding it.
And just to clarify, Your Honor, what I was surprised about was that the agreement between council had been filed. The message I got from her was that it was the clerks had rejected it. At least that's what my understanding was. So what I'm talking about is our agreed strike of the trial that we both.
Hold on just a second.
I also put the wrong number on the response to appoint a special master. I just noticed that. I did serve a copy on council though.
That I saw.
I keep doing that for some reason. I keep putting 747 says 474. So I will correct that.
And I just saw that this morning, Your Honor. I was unaware that council had served me with that document.
All right, here's the agreed order of continuance. It says a bench copy. I know I was looking at this yesterday because it says bench copy, but it has an original signature. I don't know why I couldn't use this. Does not have enough header on it. Is that the problem with that? As far as your orders, agreed orders of continuance, I'm not sure it really matters. They're both essentially the same. So
right. And it's my understanding our procedure in Calais County is you have to have a court order striking it from the trial calendar. That vaguely understood that, but I was hoping that just our agreement would be sufficient, but it wasn't.
Yeah, no, we need orders. So, Mr. Anagnostou, did you see the proposed order, Ms. Cotto?
I'm not sure.
All it says is parties petitioner Caitlin Hoffman appearing by and through her attorney Kurt Anagnostou and respondent Corey Robert Hoffman appearing by and through his attorney Eleanor M. Cotto hereby agrees to continue the trial date set for the week of March 11, 2024. Now, therefore, it is hereby ordered, adjudged, and decreed that the trial date set for the week of March 11, 2024 is continued. And then it's signed.
Yeah, I did see that, and I think per our local court rules, it needs to be in there that it's stricken from the calendar and continued.
I wouldn't want to strike it from the calendar. It's just
basically stricken to be continued. Or
I wasn't aware that that's now a requirement or it's in the rule.
I'm just going to sign this one that Ms. Cotto submitted, but just add the matter will be re-noted for further trial.
Thank you.
Okay, so it reads, now therefore it is hereby ordered, judged, and decreed that the trial date set for the week of March 11. Oh, I see what you're saying. Instead of saying, I'm going to strike the word continued and just put stricken.
And I will modify my orders for the future to, I'll double check the rule, and if that's what it says, I'll modify my orders in the future.
Agnostic, are you okay to put approved via Zoom?
Yes, Your Honor.
Okay, so I've signed off on that order. All right, so that brings me now to the matter of what we're going to do in regard to discovery. So, Mr. Anagnostou, one of the suggestions is to have your client sign off on release of information. I didn't know if you were objecting to that or not, and that way they could just get the records directly.
Again, I didn't see council's response to appointment of special masters until today. Apparently, it got served, but in the wrong stack of documents here at my office. But anyway, I saw it today and just had a brief conversation with my client. And what she tells me is that she previously signed a release for information, and they got the documents. So,
excuse me, Your Honor, can I make an objection before we go a lot further?
Okay.
Mr. Anagnosto hasn't done anything in writing, nothing.
Right.
I filed late because I half expected something to come to me so I could respond to it. So I hold off writing anything or submitting anything to the court. And then what happens is we get before Your Honor, and then I have to respond on the fly, anticipating what he's going to say. So my only reason for late, and I filed it on Friday because I didn't hear anything from him as to a written response on anything. There's been no written responses on any of these motions. So I think Mr. Anagnosto should be precluded from arguing anything because I don't know what he's going to say.
All right, so let me back up. So the whole point here is to try to get discovery done. I understand, Ms. Cotto, your objections and your reasons for the objections, and I agree that responses should be in writing. So as far as what your client says that she's done or not done is irrelevant. I'm trying to, my goal here today is to see, is there an alternative to the special master so that the cost of the special master doesn't need to get incurred? Because you're right, it's not cheap. It costs, and it's going to take a number of hours given the length of the discovery. So the only question I have at this time, Mr. Anagnosto, is whether or not your client is willing to sign off on the release as an alternative.
Right. And I was getting to that response. Counsel and I had a conversation. I thought we were trying to work this out. I didn't realize that there was actually documents filed. That was my mistake. They had, like I said, these documents for some reason didn't get into my file. But anyway, to get to your point, and I only had brief time to talk to my client. She doesn't disagree because she's done it in the past, signed releases to release information. But this request goes beyond what is discoverable. In particular, I'm looking at page 2 or page 3.
Okay, I'm going to stop you right there because that's where I just wanted to know if she was in agreement. And if you're objecting to not signing as requested by Ms. Cotto, then I agree. What Ms. Cotto has indicated is there's no response in writing, and to get into the basically the weeds of what needs to get done is going to be difficult. So
based on emails then, and based on your Honor's indication, we agreed that she struck some of your suggestions that Carly Bliss would be appointed special master.
So then it becomes the cost, because at this point, Ms. Cotto is asking that your client be paid for it. And again, there's nothing in writing. I agree with Ms. Cotto, and that creates a problem. So I'm trying to come up with an alternative here because I want this to move forward, and I'm afraid if we don't do something, it's not. We're going to be right back here again. So Ms. Cotto, do you have a suggestion at this point?
Well, I had listed my suggestion in regards to full disclosures. If they don't agree with that, then Ms. Hoffman should pay for the entire cost of this. We're only here because she hasn't provided the documents. And if she wants to pay somebody probably close to $5,000, then that's her decision. My client doesn't have that kind of money.
So, Ms. Cotto, in regard to your request, because I don't know the answer to this question, do the releases just reflect what you had asked in your discovery?
Yes, they do. Every one of them. maybe I have to double check on the insurance records. But that may be, that may not, the medical insurance records may not have been requested, and I may have to do a separate request for it because of what I learned in the discovery that was provided. So I may have to do a separate request. So that is really the only thing that that wasn't that isn't directly request or reflective of what I requested.
So I don't want to put a financial burden on either party. I understand that in many ways, this is the petitioner's failure to provide the discovery. And at the same time, having a special master is going to be very costly. And I'm gathering this is not an expense that can be afforded by either party. So the court does not like to impose such expense on parties if it can be avoided. If it can't be avoided, then bottom line is that the court will have no choice. And so I'm looking at probably that the petitioner will pay most, if not all, of the expense. I don't know. I haven't gotten to that decision. So here's what I'm going to do. Unfortunately, I'm not on the bench next Tuesday. But I'm going to set this over 2 weeks to see if council can please try to see if they can resolve this through releases. And if you can't, that I will be ordering the appointment of a special master. Ms. Cotto, did you have any preference on who that would be?
I believe Mr. Anagnosto and I agreed on Carly Bliss.
Okay. All right. And I think she would be good at her use of time and that. So I think that would be good as far as that part of it goes. So, but understand that's what I'm looking at. If you can't come to an agreement, and I ask that council please try to work together to figure out what the releases can be. If it reflects what was requested in the interrogatories and requests for productions, then that's probably what's going to need to get done. And so with that, I'm going to set this over 2 weeks and see if the two of you can reach an agreement on releases. If not, like I said, good chance petitioner is going to end up paying a large cost that I expect she's not going to want to pay.
I will be going, Your Honor, directly to these entities to get their releases. So that's, and I'll provide copies from council because I'm not going to make up mine, because a lot of times they won't give us that information with my release, or they'll want their very specific releases. So I will provide all of those to council. I will be in a conference, but I will leave my conference to do this in 2 weeks.
Okay. All right, Mr. Anagnosto, any questions?
No, Your Honor, I understand your ruling. I appreciate it. Thank you.
All right. All right. We'll be back on in 2 weeks.
Thank you.
Thank you.